This is the ruling of the court. The second respondent counsel has raised objections to various paragraphs from the testimony of Robert Joseph Mertel-Nuno, PW3, in these proceedings. The relevant paragraphs, the subject of the objection, are from line 3 of paragraph 4, paragraphs 5, 6, 7, 8, 11, 16, 17, 19, 20, 22, 23, 24, 29, 30, and 31 are objected to on the ground that they are not supported by the pleadings. Paragraph 9, 15, and 18 were objected to on the basis that they raise issues as to authenticity of documents in the election that the court has already dealt with. Paragraph 10 was objected to on the ground that the petitioner is seeking to build a new case. Paragraph 12, 25, and 26 are objected to as reflecting the opinion and irrelevant to the issues in controversy. Petitioner's counsel has argued that the objections are not supported in law because the testimony is premised on either the petition and the pleadings and the answers and prior testimony of the second witnesses, Dr. Pasa White, on the 3rd of February 2021, and the answer of the first respondent herein. We've considered the submissions of both counsel and the testimony and the pleadings in this petition. We are of the opinion that paragraphs 4, 5, 6, 7, and 18 ought to be struck out, and as they have no foundation in the pleadings or supported by the evidence, and the same is hereby struck out. Yes, the rest, that is the remaining paragraphs in the witness statement, are maintained. The petition is hereby adjourned to Monday, the 8th of February 2021 for cross-examination of PW3 at 9:30 a.m. So in fact, apart from paragraphs 4, 5, 6, 7, and 18, the rest of the paragraphs remain. Yes. Please, you have to prepare for your cross-examination when you come on Monday. You are coming at 9:30.
Bravo, my lords.
Yeah. Yeah.
My lords, we are most grateful. Order in court, please. All rise.
conference, the usual press conference that the two parties will hold. That's the NDC and the NPP. But just let's go through the paragraphs that have been struck out. Paragraph 4 says that it is my understanding also that a specific role of the chairperson of the EC as the sole returning officer is provided for in the Constitution and in the same regulation prior to the so-called declaration on 9 December 2020. The chairperson of the Electoral Commission did not perform the duties she was supposed to perform in order to be able to declare winner of the election as she attempted to do. In the entire period after the election on 7 December 2020, she made a couple of very brief visits to the strong room. This has been struck out. Paragraph 5, the EC had a video documentary person recording events in the strong room, and I have no doubt that if that documentary is available in its authentic version, it will confirm what I'm saying in this witness statement about things that occurred in the strong room. Also taken out of the witness statement of Rojo Metal Nunu. 6 says dedicated fax machine, printers and computers were provided for in a strong room that were to receive fax from fax machines and the regional coalition center in full of view agents and that of the project also taken out. We'll come back to continue with the other paragraphs, but just for you to know, paragraph 4, 5, 6, 7 and 18 have been struck out. Let's move over back to the Supreme Court for the press conference. We'll be right back. Stay with us.
Okay, good afternoon, ladies and gentlemen of the press. This morning, the petitioner presented his third witness in the person of Rojo Joseph Metil Nunu. And a witness statement prepared and signed by the said witness was filed before the court. And we were expecting that he was going to give his evidence today. The lawyers for the respondents, particularly the lawyers for the second respondent, Nana Addo Dankwa Akufo-Addo, raised a number of objections to the paragraphs of the witness statement. In fact, they raised objections to 23 out of 32 paragraphs of the witness statement. And the basic objection they raised was that those paragraphs, in terms of the evidence that was sought to be given, did not arise out of the pleadings of the petitioner. But, they sought to say that those paragraphs should have been reflected in the pleadings of the petitioner. However, a basic rule of law, which I'm sure was lost on them, is that in pleadings, you plead facts, but not evidence. And we had pleaded the facts that were necessary to ground our petition. And this witness statement was designed to provide evidence in support of the facts that we have pleaded. So, for instance, we made it clear in the petition that the chairperson of the Electoral Commission had acted in an unfair, arbitrary, and capricious manner. And the evidence of Rojo Metil Nunu, together with the evidence of Dr. Kwesa White, which I'm sure you witnessed the other day on the 3rd, was meant to make it clear the extent to which the chairperson was capricious, was arbitrary, and also unfair as far as the petitioner's case is concerned. And so we were taken aback when they sought to basically throw out the entire witness statement, saying that it was not supported by the pleadings. But as you have seen, I'm sure the court took a different view, and out of the 23 paragraphs in respect of which objection was taken, it was only 5 of them that the court said should be struck out. And for us, that is a great victory. We will not comment on the substantive content of the petition, of the witness statement, because he's yet to be cross-examined on them. And I'm sure on Monday, when we return to court, the cross-examination will take place. And thereafter, if there are any issues arising out of or in connection with the cross-examination, will address you and clarify those issues to your understanding. Any questions?
Doc, we previously asked about the impact that your witness statement being struck out will have on your case. In this particular instance, if you read the paragraphs 6 and 7, very serious allegations that once taken out, you should be worried about. It talks about fax machines not working and someone just walking into the strong room with documents coming from wherever and using it to collate results. I mean, you should be worried that such important piece of information is not going through this particular case.
Well, that is so. If you watched lead counsel, Mr. Tikata, on his feet, he made it very clear that in respect of paragraph 6 relating to the fax machines not working and people walking in with information or faxed documents and so on, that the evidence was meant to make clear that the systems that they had put in place, because remember that in first respondent's answer, the EC said they had put in place a seamless and transparent system for the collation of results. And paragraph 6 of the witness statement, which you correctly identified has been struck out, was meant to say that the system that you call seamless was in fact not seamless, that it was in fact dysfunctional, and that the fax machines were not working and there was frustration in the strong room. Of course, that is not the only evidence that we are providing. The rest of the paragraphs detail whatever took place in the strong room, and we think that ultimately, if those are taken into account, the probative value of what our witness will say will rise up. Any more questions?
You mentioned that what just happened is a great victory. I want to find out in what context are you speaking? What do you mean by great victory?
Pardon?
You mentioned that what just happened in court is a great victory to you. And I want to find out in what context are you speaking? What exactly do you mean by that?
Well, of course, if the objection was taken to almost the entire witness statement, if you watch Akodo Ampa on his feet, he listed 23 out of 32 paragraphs to be struck out. Now, if you take those that remained, say paragraphs 1 to 3, those are just introductory paragraphs about who the witness is and so on and so forth. So basically, if the entire 23 paragraphs were struck out, then it would have meant that we would have basically an empty witness statement that will not be supportive of our case. But here's the case: we have only 5 out of the 23 being struck out, and for us, those 5 do not materially damage the case that we are seeking to make by bringing Rojo Metilnunu as a witness in this matter. So that is why I'm saying that it was a victory for the petitioner as far as we are concerned.
All right. Thank you very much. Forgive me for my ignorance, but I believe that the petitioner came to court to prove a point, the point being that neither of the 2 leading candidates attained more than 50% of the total votes cast. Now, the witnesses we've seen so far have spoken to other matters other than the figure 50% or less. Even today, the witness statements that we have seen does not address the issue of whether somebody attained 50% or less. Are you shifting the goalposts?
I don't think so. I don't think we are shifting the goalposts. And then, also, first of all, in his testimony, PW1, the General Secretary of our party, testified to the issue of whether or not any of the candidates crossed 50%, the 50% threshold as required under Article 63 of the Constitution. All right? And of course, you saw that they brought calculators and sought to get him to calculate figures, showing how many votes were won and so on and so forth. So that is what when we addressed you, we said that is the mathematics of Article 63. But this case is not only about the mathematics of Article 63. The case is also about the constitutionality of the conduct of the Electoral Commission chairperson. And then also, more materially, about whether and the extent to which the declaration that she made is constitutional. Okay, that is an important point that we keep emphasizing, but it looks like there is an attempt in the media to reduce this case only to one issue that we have brought to court. It is not only one issue. There are weighty issues of law that the Supreme Court is being invited for the first time in the history of our constitutional democracy to determine. We underscore the point that this is the first time in the history of our democracy that a chairperson has declared, a person, president-elect, based upon one set of figures, and then subsequently, repeatedly revised those figures. The question is, and I keep saying, can you put something on nothing and expect it to stand? It will not stand. And we are asking the court to declare that her conduct in terms of revision did not comport with law, did not comport with the Constitution, and therefore should be that declaration, together with the President-elect Declaration Instrument, CI 135, should be declared null and void and of no effect. And that has constitutional consequences. Of course, we cannot comment on the constitutional consequences because that is left to the court. But we are inviting the court to declare that her declaration, together with the instrument based upon which that declaration is now law, and for which reason Nana Addo Dankwa Akufo-Addo was sworn in as President of the Republic, are unconstitutional. That is an important point that you in the media must bear in mind. Any other questions?
Now, the last time when Dr. Kwesi White tested before the court, your colleagues on the other side were saying that if indeed Rojo was the one who the EC chair spoke to, he should come testify. Now he has come, and per the paragraphs that your colleagues on the other side were asking that be struck out, is there an indication that they will not be comfortable having Rojo testify before the court?
Well, that is a very obvious point, in the sense that they were saying Kwesi White, basically was giving hearsay evidence. Now, the person who was, in the strong room with him and who can corroborate what he is saying is being invited to give evidence. And the same people who said Rojo Metil-Nunu ought to have been called are now saying that he should not, be allowed to present evidence in full in respect of the facts that, of events that took place in the strong room. Now, I'll leave that to your judgment, and I wouldn't want to go beyond commenting on whether or not, the evidence that, he will give will corroborate what Kwesi White, provided to the court. All right, so.
Let me do the trick quickly. Okay. Yo, and say, and then you see our court in 8 yawa. Anka ene, and anka ye dancing ya or tosomiansa, anka oba bejina adekan wakasa, muhu say, and nam in some sembinti, anka ye no fa abefu fidieso, no bia ashe no TV so. Now so, eye yenuanom a ewo eye Nana Akufo-Addo ne lawyers eso original ho se ensem na ye dance din no ode abetu dwa no ensem bebre wo mo mpesi yi firimu te se mre bi se ne omo ye no se ensem omo ka nanu nso a eye Dr. Kwesi White by no wo mo anomo ka se Dr. Kwesi White no no na oni isi kasa ye nti awo senka ne oni isi kasa ne na eba sese ni oni yisi kasa ne ankasa abanso a moso ne nsem na ode bae no eye eduasa miensa no omayi nka mpesi yi eye eduonu miensa firimu eye eduasa mienu ko mpesi nka yi eduasa miensa firimu 23 na nso ko wie kire no Supreme Court say emu enum pe en obeyi firimu timinimo ka sei 32 no a yede baaye no emu enum epe ene be free so enti asamo yede baaye ni na ne dodo na nkasa ejina ne nanso a enye se we ntinyame ya dom na duade ye ba enne ye nipa no be wura adaka mu na ne wo se o ka kire amanfo no waka kire amanfo emi da mase.
So first Akamba,
The protocol, come here, the protocol. Go here. We didn't keep to the protocol. Which protocol? We said they were supposed to come today first.
No, but you say that doesn't mean it's no. We are discussing. We are discussing. We are discussing.
Colleagues, good afternoon. It's been a long day in court, and we have an opportunity to share with you a few remarks from our side as we wind down today's activities. As I mentioned, it's been long, but it's been a necessary exercise of going through some objections and then hearing the responses and having the court make a determination of what it would allow and what it would not allow in the witness statement. Let me start by recapping where we are in this trial and why we are here. The petitioner, Mr. John Dramani Mahama, former President of the Republic, invoked the jurisdiction of the Supreme Court, among other things, to say that based on the data contained in the declaration of the first respondent and the second respondent being declared as President-elect of the Republic of Ghana, no candidate will obtain more than 50% of the valid votes cast as required by Article 63(3). The petition also essentially makes the argument that the threshold of Article 63(3) was not met and that the declaration was in violation of Article 63(3). Goes on further to say that there were errors and mistakes and other things which will materially affect this election, and outlined 5 witnesses who would help adduce evidence to prove same. We all witnessed Mr. Johnson Asiedun Ketia come into the witness box and give testimony, and I think the jury is out on whether or not he was able to establish any of these things. And then we had Dr. Kpesa White take the witness box and mostly lead evidence to the effect that they considered that they were deceived by the EC chair to leave the strong room when the national or the presidential final results were being collated. Indeed, the word he used was that he was instructed, and subsequently he admitted that he cannot be instructed by the EC chair. Now, today, the petitioner introduced a third witness, Mr. Rojo Metil-Nunu, who was one of those 2 in the strong room, who is the one that we were all expecting would take the witness box initially. And there were a number of paragraphs that he had outlined that he wanted to adduce before the court, some of which we objected to. In the end, the court upheld what we believe are some of the most substantial ones, paragraphs 4, 5, 6, 7, and 18. The court upheld those ones and struck it out. On Monday, we are coming in for cross-examination. Like they say, it's one thing putting something before the court, it's another thing defending it when it comes to cross-examination. And so counsel on our side, and we believe counsel on the side of the first respondent, look forward to an opportunity on Monday to now put the paragraphs that have been admitted in Rojo's witness statement to the test under cross-examination. Essentially, that is what has happened today, as I'm sure you are aware. We are happy that finally Rojo will be in the witness box so that some very important questions can be put to him and the bench or the court can take judicial notice of whether or not those answers to those questions and those arguments that are being proffered go in any way to help deal with the issues before the court. And as I wrap up, let me take you through the issues. Sometimes when you follow the long conversations, you forget what the court is trying to answer. The court is answering 1 question of law, 3 questions of fact, and 1 question of law that arises as a result of a fact. The question of law is whether or not the petitioner in his petition has any reasonable cause of action. The questions of fact are whether or not, based on the data, nobody got 50%. whether or not the Article 63.3 threshold was met is a question of law, as I've mentioned earlier. But whether or not you include or exclude Techim and South, does it change? And then the other question of fact is whether or not all the so-called errors and vote padding affect the outcome of the presidential election results. The last question of law, which comes from fact, is whether or not the declaration will therefore be in violation of Article 63.3. If you find that at all material times Nana Akufo-Addo exceeded the 50% threshold, then that question of law will be answered in his favor, that then it was not unconstitutional. So we believe that we are making progress gradually. We are at a point where the third witness will be put in the box, and we'll see whether his argument stands up. What is interesting to note is that when our colleagues don't get a win in the wells of the Supreme Court, when they come, they say the decisions don't make sense, that the court is not being fair to them, etc. But today, you notice that as they got some of their arguments upheld, they seem to think that the course is the best so far. But we'll live to see what is out ahead of us. They describe it as a great victory. And let me explain to you why they describe it as a great victory. They describe it as a great victory because they realize that Dr. Kpetsahoi's testimony fell flat, could not stand the test of time. And therefore, they've tried to bring in Rojo, who initially they came with some reasons not to bring, so that he can. And if you listen to the arguments of counsel for plaintiff, Mr. Chachuchi Kata, he makes the argument that during cross-examination, some very significant damage was made to the argument. And therefore, it is proper for them to bring in Rojo to try and re-establish some of those ones. So for them, if many of them had been struck out, it would be a very devastating day, because then it goes to buttress the point that where Rojo failed, where Kpetsahoit failed, nobody can attempt to save him. Now, they seek to bring in Rojo to try and save Kpetsahoit where he fell flat. And we are pleased that at least they are no longer trying to poison the minds of the public against the court. We look forward to what Monday will bring. We'll take your questions.
All right, so the first question I ask is that today in court, after lawyer for the petitioner finished his submissions, we saw the lawyer for the Electoral Commission, the first respondent, making an argument that it appears the court it seems to be going a certain direction in a petition, where they are allowing the petitioners to speak before the respondents, when it's supposed to be the petitioners first before the respondents. Is this something that you identify with as second respondents? Because I didn't hear your lawyer talk about it. Are you going to raise issues with it?
That's true. Well, let me quickly respond to that. What the counsel for the first respondent said was to draw the attention of the court to the fact that the procedure as it's unfolding, it appears to be deviating from the norm. The norm is that the petitioner makes his case first, and then the respondent responds. And even by CI 99, you are not allowed the opportunity of a reply. If you look at witness statements, for example, the petitioner refused the orders of the court to file the witness statement. What it meant was that the one responding rather put in his witness statement, as did the first respondent, and the petitioner then had opportunity to read it and attempt to now put in witness statements. So it's like the respondent is now going ahead and the petitioner is looking to how to close their gaps behind. In the case of calling witnesses, properly so called, you will notice that at the deadline for filing witness statements, Rojo Metelnunu's statement was never filed. They came to see the justices in chambers and made an application, which we didn't object to, because we believe there are some questions he must answer. But what has happened is that after Kpetsahoit has been cross-examined and his case has fallen flat, then they bring in Rojo seeking to correct or salvage some part of that case. It is that which the counsel for the first respondent is drawing the attention to the court, that that is not the normal practice, and that they are literally allowing the petitioner to turn the rules upside down. I think it's obvious that the court is being very magnanimous. In fact, he used the word magnanimity. The court is being very magnanimous in hearing all sides and allowing things that ordinarily it will not allow. But, like we keep saying, always go back to the issues. What are the issues that the court is seeking to answer? And we are of the view that whatever things about fax machines not working, about phone call that they couldn't hear from, and then about deceit and a few other things, whether or not it changes 4751.2 or it changes the constitutionality of Article 63.3, something that the bench will determine eventually.
Right. I have this simple question. Yes, that was on Wednesday. You asked.
You have to
said,
speak up, sir, so that we can hear you.
On Wednesday, you said that the court is a place of law, and then on your previous interviews, you also made a statement that justice is denial of justice is delayed of justice. Or I don't know.
No, I haven't said that.
Delayed. Yes, exactly. Sorry. And so, with that, putting law and justice together, if each of them is contradicting each other, which one do you choose? Law over justice or justice over law?
Well, in the end, the court seeks to do justice and seeks to do it in accordance with law. Justice must be done, but justice must be done in accordance with law. You cannot do justice outside the law. That would be extrajudicial attempts to establish justice. We've had a history in our country where some people have elected that they don't want to do things in accordance with the law. They have executed people without due process. They have confiscated properties without due process. We have now come into a democratic era. So everything, including justice, the rule of law, is hinged on the Constitution and is hinged on law. So justice is what we expect to be done in this manner, or in this matter, and we expect that it will be done in accordance with law. That is why whatever prayers we have, we'll say it before the court, they will rise, think through it, and then they will come back. What we must not do is to bastardize the courts when we don't get our way. And that's why I made the point that you notice that our friends, when they don't get their prayers upheld, they come here and they say it doesn't make sense. They are not being fair. Today, when some of the arguments are upheld, they literally say that the court is the best court that they have seen. We must be consistent. We've been consistent from day one, that we are in the hands of the court. Yes, sir.
In terms of what transpired today, there are some who look at it and say that your side should be concerned in that the 18 issues that went through were matters that effectively came up during cross-examination. Unfortunately for your side, you've already filed your witness statement. You would only have the opportunity to re-examine your witness and cross-examine the other witnesses. It means that you will not have the window of opportunity to put through and respond to some of the issues that may come up during cross-examination like they had in this particular instance. I mean, that should be of concern to your side.
Well, not exactly. Let me explain to you why. First of all, where are we in this process? We are at a point where the petitioner is still trying to establish his case. The petitioner has not established his case or has not told the court that they have closed their case, that they believe they have substantively made a case before the court. What they've done is to make some pleadings and call two witnesses so far, Johnson Esiedun Ketia, the General Secretary and the coordinator of the entire electoral program, who came in, calculator in hand, he ended up with 4751. 4751, plus or minus Techima South, 4751. You never saw him calculate and say nobody got 50%. Then they moved on to Pesa White, and you were wondering whether he will also come and perhaps be the one to provide the evidence that will show that nobody won. Because remember, they have told the millions of their supporters across this country that they won. Many of them believed them, got on the streets. They came to court, now they say they didn't win, but nobody won. So at least you were expecting that one of their witnesses will prove that nobody won, even if you forgive them for the first exercise of deceit of the Ghanaian public and their supporters. Pesa White gets into the box, and the gravamen of his testimony is that they were deceived by the EC chair. He uses the word instruct to leave. And at the end of his testimony, one question from Counsel Akoto Ampao, I put it to you that you cannot be instructed to leave, he admits, and the whole testimony crumbles. So now you find that they go and bring our very good friend Rojo Metununu, who we were all hoping they would put in the witness box in the very first case, because he was the one granting the TV interviews and claiming in those interviews some things, which I won't say now because cross-examination hasn't started. They are now at a point where they are trying to make their case. It is when they succeed in making a case and tell the court that, my lord, we have closed our case, that a certain threshold may or may not have been met, in which instance we and the first respondents may have an obligation to also open or advance a case. So it's early days yet. Bear in mind that they have made some specific allegations out there. They have to prove it in the court of law. Until then, we don't even have a case so much to make. We are ready. Chairman McMahon comes every day with his pink sheets and his regional coalition sheets and his Form 12s. And is ready that if it becomes necessary that he mounts the witness box and prove that Nana Akufo-Addo indeed got 51.2 and beyond, he's happy to do it. But they have to prove their case first, because he who alleges must prove. Check section 14, section 17 of the Evidence Act. So Rojo will have to now come into the box, make his allegations, prove same, and be cross-examined on it before we move to the next steps.
Your side during Dr. Kwesi White's cross-examination indicated that the petitioner couldn't have brought Roger Metel because there was no way he was coming to be able to confirm what Kwesi White was saying. Now, today, your side made an attempt to almost take out the paragraphs in Roger Metel witness statement. Now, you are saying that you are happy Roger Metel is coming. How do you link these two to you saying that you are happy that Roger Metel is coming to
First of all, let me show you what is interesting. There are supposedly two people who have been sent to go and protect the interest of Mr. John Dramani Mahama at the EC Strong Room. Person one is the principal party. Person two is more or less the supporting actor. Person one goes to have a conversation and supposedly reports to person two that both of them should leave. And at the material time when the petitioner wants to adduce this evidence, he opts to bring person two and says person one should come and corroborate. Anybody who is following it begins to realize that something funny is going on here. Because ideally you will bring in Rojo and then rather look to get somebody to corroborate, assuming his evidence is not enough. They flipped it the other way around, no wahala. But we are happy to have Rojo in the box because there are some questions that will be put to him. That is why on the other day we were saying that perhaps they didn't bring him because they were of the view that if he comes, he will perjure himself. Now he has come, he has tendered in his witness statement. The technicalities of what must be accepted and what doesn't meet the standard have been dispatched with. Now the questions are going to be put to him to see whether his argument, what they tell the NDC supporters, what he told the supporters, whether I can stand the test of scrutiny in court. And that's why we're very pleased at where we are. Remember, a case is now being made, and we are now at the point where we are cross-examining that case. When it is done, if we have to now get into a full response, then we'll get into it. I want to say thank you and invite my colleague Fatih to sum up in chief for us.
Honorable Kojo Ponkroma, Minister Designate Eddie Abreno, who be here say, Mebono Tofa Akankasem. Na Nienti a PMU a Haneno, Mijidi Sawa Woody in Semning in Echi no Obekaya, a former President John Dramani Mahama, and Wasama, a electoral commission. And President Akufo-Addo Asenibiaha say Abaya Koto on 7 December Nebobo any declaration by ne bonyoso na sese no ne asem na kodu ni de beba na emom ye pese e kan mo say ensem na court no be kan nyina omu bebua ne manum na ne edi kan ene say asem a o matchegu petition no so de aba be dan court no say wo nyina so ana say ni nyina so ne etoso mienu ene say court aya bai aba ye to on 7 December no presidential candidate no obi anya ohamu abupen aduonum ni echi ebio nso so court no ebebua say eye declaration na EC ba panyima me Jean Mensa o declare no say ebuga na mrapon na say embu mrapon no na ebio obesa bua say eye aba oto wo Techiman South abato mpesu aso no senka o the results no ebobo etwen bobo kan ho anka be ye nsakiraye bi e wo abato no outcome no ma na ne etwa to okra ene say allegation bi a petitioner ne de aba say mani bi o ha nkontabuo mu ne ye de kan obi de ho se sa ama no ye bua ne nyina say betime de ensakiraye bi aba abato no nsunsu anso so ana na sansemu num yi na enema ye kan o court ha nyina le wi a court no bebua na samu be kan a na no ukuada a court no sorry asem no so no na ye hwe anim si ebehia na enra eye petitioner no ebo court no kokose nyame ya adoma anapai o mbesa de odansini foforo abeka ho so obekan a ebra petitioner no file petition no obo court no kokose nka obefre adansifo num enso so asat ukuada na ye free ha say na adansefo na emu mienu pe e na pe witness statement e ba ne cross examination ayaye no maba enti sa kokoboy ehu asem nanka na pe ye ba betie sa adanseni otoso miensa eye owura Robert Joseph Metal Nunu na no asem na afei nso so eye electoral commission ne president na Akufo-Addo ma lawyer for enso so anya akwanya atoto na no na enso so ye bepie mu aha na pe obakan a eye adanse a owura Robert Joseph Metal Nunu ochrogu krata so e ma lawyer for de bepie mu aha no na president Akufo-Addo ne lawyers a lawyer penyo odi anim eye owura Akoto Ampaw o se ensem ni bi wo ha otiem na edi enti na nsem na no mode abeda court no so otiem na otiem free say sa wohwa emra na ede adwuma wa ha say na odansini na yayi no enyo no de na asem abeda court enti nke be ya ensem a wode ba aba na adanse a wode ba court na nim no esese ye ensem a ewo fapem ewo petition na mode abeda court no na eni kwan say ye ensem a ne petition no mu ensem a na pleadings no ebo ebra na ebio ensem ni bi won so a eye omampanyi lawyer owura Akoto Ampaw o ne mpanyimfo akuku da meka no ho ehun se eye ensem anka ene asem a ye kan emfa kwan bia so nanso so omo pe kwati kwan bi e de aba be hyem na afen so se ye ka witness statement na esese nka ye ensem a ye unim dia na bibia unim hu bia na udi hu adanse enya adwenkyere na nsem na omatweregu witness statement no emumu bi nso so ya adwenkyere a ene mra no nso so bo ebra enti anapa owura Akoto Ampaw etia nsem ni bi mu e ma court no nso so ma eye petitioner no lawyer akwanya mo no nso so e kan bi na ne court no e kan kosi ya ne say ensem na e wo witness statement no mu emu paragraph 4 5 6 7 any paragraph 18 there court na twam say eni nyina so ni nsunsuaso bia wasem a ye beka mu na no krampo nkyere say witness statement na aka na yeje mene da bi enam se afe na abeda court nanim na ye ade o magye se o mo be ye ebehwa me ade ye adwumanti afe na nyame adoma ejuada se a lawyer for first and second respondent enya akwanya o mbegina sansem na owura Rojo Metal Nunu ade abeda court no ahwe so na omode atoto na no enti ne na court so court na mabọ no tofa a kire mu no timedamase na general wahana kakra me pese me de ka ho ne se mo be kan a utimi ho se adansefo a petitioner ne di kan fra mo be gina adaka mu eye Owura Johnson Esiedu Nketia a wono na general secretary for NDC na aba ye koto ye no party na aba ne ho ne nkan ne bibia wona na edi mutintiman ene Owura eye Dr. Michael Pesa White adanse o mo de ba nyina the way na adanse no mu oha nti utimu se no na aba mu ho a eho abehia se omunipa ba kwa na aka strong room ho no atoko se so omukotwe ne begina adaka mu nanso so se wo hwe witness statement ya aba ene ya ene dada aba no ensonso ye bi anhye da ni musa eya asomasoma ne yesoma me ya no musa de beda court na abekan a ebra na eye president lawyer penyo Owura Akoto Ampaw eye Owura Pesa White cross examination o ka che ne say unyo obi a EC chairperson no wotumi sa osoma wana sa ohyew ema sorry free sa coalition center ho no moko na sa asemo ye de pem no bo no wantima anyi ho achinyi oje tumu se EC chairperson eni tumi bia ode be soma no enti ye hwe anim se nyame adoma adwada e wo ye anim se ne dada ne ye no sa na we nso be ye because ye hwe ye hu witness statement no etisa sa wana enti nyame adoma ye gidi se a lawyer for akuku dam omudi anim no ombetetim medam wase.
The two press conferences, of course, the press conference that was just shown to you was that which was addressed by the second respondents spokespersons. These are spokespersons for the second respondents legal team. The lady who spoke in Chi just a while ago, Fatima Abubakar, one of the communications directors at the presidency, but earlier on the Minister for Information Designator, Mr. Kujo Ponkroma, had also addressed the media. But before then, the petitioners' legal team came to speak also to the media, and they also spoke both in English and